Hi, Colby here. And hi, Colby here. Welcome to Hold My Briefcase, where we talk about legal issues that affect your everyday life. And today, I'm just sitting here at the office, finishing up federal motions and federal practice. And, a lot of people ask me, like, what's the difference between, the different courts, right? And you hear people say, "Oh, it's a federal case. Oh, it's a state court. Oh, and they're here in district court, and they're in general practice and JP court and criminal court and this and that." Well, let me try to help you with it. In Texas, there are different kinds of courts, and there are jurisdictions based upon how much money is involved and the specific issues. Now, look, there is very, very, very explicit and technical issues to address here, but that's not what this podcast is about. That's not what this discussion is about. What we're talking about here is generally. So, first thing you talk about is what's called a small claims court, and that's what you think of when you think of Judge Judy or the People's Court. And these courts have limited rules to them. For example, there are no evidentiary rules. The procedural rules are really reduced. And the whole point is that the people, not lawyers, uh, can do their case for them. And the judge is supposed to act as a facilitator. So the judge will ask questions. The judge will be the one running the show. Kind of like what you see with Judge Judy. She talks to them, she shuts them up, she gets evidence, and she makes a decision. Great, right? Well, it's great if you get a judgment, but if you do get a judgment, the judgment can be appealed automatically. The next level up, which is civil courts at law, civil courts, county courts. Now, the county courts are a jurisdiction that falls in between the district courts and the small claims courts. And this is having to do with how much money is at issue. And they change this all the time. But basically, think about it like the county courts at law are your smaller claims courts, not still having full evidentiary hearings, still having full judges. These are the courts where you're going to find a little more, routine, a little more volume going through them. So you'll have a lot of eviction hearings, a lot of HOA hearings, a lot of people trying to collect on debt. The problem is that the court pushes very fast in order to get resolution at this level, and sometimes it's not enough time for really big cases to develop. Remember, just because we file a lawsuit doesn't mean they're going to participate or agree with us. We usually have to go and ask for documents and take depositions during a phase which is called discovery. And in discovery, the fight is what are you going to give us and what are you not going to give us? We say, hey, we want all the documents. They say this. They say no. What do? Well, we got to go fight in front of a judge. And we ask them for documents. They get 30 days to respond. After 30 days, they don't give us any. Then we're required by law to go and do what's called a conference and try to get them to agree. And a lot of times they don't, which means that we now have to get a judge involved. And the judge can make a ruling, which the judge might take up to 2 to 3 weeks to get a hearing. And that's after 2 to 3 weeks of drafting the motion in order to support your hearing. Then after the hearing, the judge can take a little while to rule. So these little discovery issues where you're trying to get just simple pieces of paper out of the defendants can take 6 to 8 months from start to finish. And this is by design. The defendants aren't required to play nice, and in fact, a lot of them don't. So what we have to do is we have to hold their feet to the fire. We have to be aggressive. We have to make sure that we're getting what we need from them so that way we can make a case. Remember, we can't just go in to court and say, hey, we suspect this is what happened, therefore give us money. Can't do that. You have to have affirmative evidence. You can't have negative evidence. What I mean by that is you can't say, well, this person, you have a person who was involved in a surgery and, they after the surgery, they can no longer, walk 100%. And so the question is, did this cause this? Did the surgery cause this? Most people will say, yeah, of course it did. You went into the surgery before, you could walk, came out of the surgery after, can't walk. Pretty simple, right? Well, unfortunately, the court will require what's called expert testimony, which is another layer of complexity. So you can see very quickly how even a basic, straightforward claim, when it turns into a lawsuit and it's brought against people who act in bad faith or people whose sole intent is to string it along and say no, basically. The people that are against us are literally paid to say no. If we tell them the sky's blue, they pay them enough money to say the sky's purple. We just can't win. Truly. And they're paid not to agree with us. And so the only thing we can do is to get the evidence against them through the discovery process, which basically makes it to where they don't want anybody to find out. They don't want anybody to know what they did. And that is where we come in to say, look, we can make this public. We can show everybody your incompetence. We can put it on full display. It's unfortunate that a lot of times when, we go through this and I do all this work and it's a big buildup, right? You're working on these cases for years, sometimes, and, 60-hour weeks of just working on one thing. And you make a breakthrough and the other side finally admits that they're in trouble and they want to settle. I would love to tell you a lot of stories about that, and I can in the abstract sense, but, the insurance company pays extra to make sure I can't tell you specifics. They call it confidentiality clauses. And they hope that, if I'm not allowed to tell people specifics, then that way you won't find out about me. And I won't be able to help you. It's not that I don't do a good job. It's not that you're not entitled to it. It's not that the insurance company is not bad, because they are. Everyone agrees. It's just them trying to hide the ball, trying to make it to where you don't learn about me. And so I can't help you go against the insurance company. And they know that. And they know the value that I bring. They know my results. And when I come on a case, the insurance company has to take notice and they have to reevaluate it, because my firm has and will continue to do very good against these insurance companies. And look, I wish I could tell you it was because we're so smart and we're so good. And I think we are. The reality is the insurance companies are just that bad. Straightforward. You send in your medical records, they don't respond to you for 6 months. You try to call them to get your claim taken care of. You go through a maze of answering machines and buttons and policy numbers and returning calls. You are required to go through their system, and at the end of their system, you get their result, and their result is not a good result for you. In the end, nobody is ever going to give you anything for free. It makes sense. And in fact, the insurance company delays, denies, and defends. They'd rather defend their decision by paying a lawyer to defend the denial that they shouldn't have made, that they spent months or even a year delaying you to get you an answer that isn't right. And unfortunately, there is a 2-year statute of limitations on negligence claims. So the hope is that if they can get you to delay, then if you do go see an attorney, they'll just say, oh, well, you have this big gap in treatment. We're not going to pay you. Or, it's already too late. None of this has anything to do with how good your case is or how bad the insurance company is. It's all just games that people play. They taught me in law school, if you can't win on the facts, go win on procedure, right? If you're a semi-truck which was operated by a man on PCP, slid into another car and killed them, avoid those facts. Instead, talk about this little issue with their medical records. The strategy is to try to take something and divert your attention. Oh, don't talk about the PCP. Let's talk about the fact that this guy had a pre-existing condition. Yeah, well, he had a pre-existing condition from high school. He had a little knee damage. Well, your truck ran into him at 60 miles per hour. And then that becomes the fight. The distraction from the real legal issue is what the negligence was of the trucking company. But every year, through legislative changes and through decisions, less and less of the surrounding negligence gets shown. You don't get to see all the other violations that the trucking company had. You don't get to see, some of the evidence because it's excluded. Because the legislature decided they don't want the juries to see it. The legislature wants to limit the jury's ability to award compensation. And you're going to see that over and over and over again. And this is effectively closing the courthouse doors. So that way people like you don't get the opportunity to even fight them anymore. They take away every thing you can do little by little until you're left with nothing. It's a system that you're required by law, in the case of automotive, to pay. And everybody knows the system is kind of broken because the insurance company doesn't have your best interests at heart. And so when you're dealing with the insurance company, you need to remember that. You need to take good notes. You need to be on your game. You need to make sure that you're prepared. Don't answer questions you don't know the answer to. Don't guess. And get help. Because having a good lawyer, having a good advocate, having a fighter for you not only changes the outcome, but it lifts that burden off your shoulders, that stress, the anxiety, the heartache, the time, the aggravation. All of that you get to put away and focus back on your life, which is important. Because if it takes away your life, you're a victim twice. So there's lots of issues in the world today, and these issues, are a lot more complex than we let on or we think. People hear about lawsuit abuse. People hear about hot coffee cases in McDonald's or Starbucks. And they don't realize that this is literally propaganda created by the insurance company in order to create a bias because you're a juror. And if they can create even a little bit of bias, even a little bit of hesitation, or even a little bit of prejudice to where people prejudge people before they even get in through the courthouse doors, or people who think that you would go 3 years and then sit in a courtroom for months because you win, you get a lottery, you get a payday. There's no amount of money that people will take to put them through that misery. Most people do it on principle, and they do it because they know if they don't, the insurance company is going to win, and they're going to get away with it. So don't let them get away with it with you. Be assertive, be firm, and be informed. Don't rest on your rights. If you have questions, call a lawyer. That's what we're here for. So my name is Colby Lewis. This is just a brief stream of consciousness ideas here. But thank you for listening to Hold My Briefcase, where I talk about legal issues that will affect you in your daily lives. I look forward to seeing you again.